done business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning, everyone, and welcome to an oral argument session of the 5th District Court of Appeal. The Marshal has introduced me. To my right from Orange County, we've got Judge Eric Eisnagel, and to my left, we've got Judge Meredith Sasso, also from Orange County. We've got a number of cases on the docket this morning. We're going to take them in the order upon which they appear on the docket. If you have any electronic devices, cell phones, anything that's going to make noise, if you could just place them on silence so that they don't interfere with the flow of the argument by the lawyers. My default on time for rebuttal is 5 minutes, but that is entirely up to you. I'm more than glad to accommodate whatever time for rebuttal you would like. So let's begin with the first case on the docket, Taylor versus State.
Good morning, Your Honors, and may it please the Court. I'm Marcia Silvers, and I represent the appellant, JARROD Taylor. I would like to reserve the default 5 minutes for rebuttal.
You got it.
Your Honors, as you know, I've raised 4 issues in our brief, and I'd like to start my argument by talking about the erroneous admission of the Williams Rule evidence. And I think this issue raises a real concern, especially in this case. And the concern is that in their zeal to stamp out child pornography, the state has swept up men like Taylor who are using these torrent sharing programs to get legal material like movies or lawful adult pornography and stumble upon child pornography, but they do not seek it out, they don't save it, they delete it. And then to make the charges stick...
Wasn't that disputed? Wasn't that the subject of some debate as to whether he actually did delete this contemporaneously upon its discovery or not? And isn't that a question for the jury?
If the court's question is, was there a debate as to whether or not he deleted the charged child pornography, there was no debate. All the charged child pornography was found in the deleted, lost file.
I thought you were talking about the Williams Rule.
Now I'm talking about the Williams.
So I think that's what Judge Cohen is asking you about.
Yes, and that is the rule. Yes, all the other was deleted, and that's why they use the.
But wasn't there a question
Williams
for the
Rule.
jury to determine whether or not, files were deleted timely or immediately?
Yes, it was. It was an important issue.
And wasn't there some evidence that the files were not deleted immediately?
And that, yes, but.
So isn't it a question of fact for the
Not by
jury?
clear and convincing evidence, and that's where.
So you want us to reweigh the evidence and decide that it wasn't clear and convincing?
Yes, because that's the standard, and the state has to prove for Williams Rule evidence. The state has to prove that it's clear and convincing, and when they don't satisfy that standard, courts have reversed. And they have to.
He admitted, though, that he indicated to the officers where he would have saved the material. That's where the material was saved. He indicated that he was the person behind the computer. The only other people in the house were minor children, very young children, and his wife. And that was all cleared up by his own admission, so how does that not rise to the level of clear and convincing?
Your Honor, he never admitted that. First of all, if you read, I know you're talking about the 2 interviews, I guess, the 2 pretrial interviews. During the trial, he stated clearly the same thing that he stated repeatedly during his pretrial interviews, and that is that he never knowingly downloaded child pornography. And I think what the confusion arose was because there were 2 different police officers asking about 2 different things, adult pornography and child pornography. And when one would ask a few questions about
And certainly that was the issue that the jury was ultimately asked to decide, but in terms of admitting the Williams Rule evidence, there was sufficient evidence to link him to the images that were stored, presented to
No.
the trial court.
He testified that he didn't know that that Lolita 238 folder even existed. And
Well, wasn't there testimony, wasn't there some evidence that it wasn't a computer-generated file, that a user created that file?
and I would refer, no, Your Honor.
No?
At pages 297 to 298, the state's own expert said, I can't say that Taylor himself created the Lolita 238 folder. BitComet, which was the torrent sharing program, could have automatically created it. BitComet can create a default download folder, although the user picks a different folder. And that's the scary thing about this, because BitComet takes bits of people's folders, and thousands of people's folders for something like a movie, and downloads it all onto your computer so that you can download it faster. And then by doing so, you often get things that you did not intend. Also, because the titles of the 404 evidence, the Williams Rule evidence, that's all the state had. And the state's own experts said titles can be misleading. The state's own experts said that. And when you look at the title, in fact, of the original child pornography that led them to him, which they never actually found on his desk, but which started this whole thing, that was mislabeled, grossly mislabeled. It was mislabeled as 8-year-old girl gets raped, and it turned out to be a girl urinating. The torrent titles are misleading, and that's all we had here.
Let me ask this, because I'm struggling with the preservation of this error. At the pretrial hearing on the Williams Rule issue, my recollection of it is that the lawyer for your client stated that there was no objection to the Williams Rule evidence coming in, and the objection made at trial was not the same objection that you're making here on appeal. So how is this issue preserved for our review?
That's a good question, and I think it's an important question because the state has raised it, and I've also addressed it in my reply brief. First of all, there was an extensive argument about the admissibility of the Lolita 238 file. It goes on for many, many pages, and that's because the defense attorney actually asked for the jury to be excused so he could address this issue.
There was a pretrial hearing before that.
Yes, and he left some, he didn't object to some of the Williams Rule evidence, and he left some open. And that's why the prosecutor, when it came to this particular evidence, said, Judge, I'm going to tell you now, this is one of those where it was left to be decided.
Okay. So are you suggesting that there is some Williams Rule evidence that came in that was not preserved for purposes of appeal, and others that was preserved? Or are you making an argument that all of it was preserved? And if so?
The only Williams Rule evidence that I'm concerned about here is the Lolita 238 folder, because that's the only evidence that the state had to prove that he didn't delete immediately everything that was child pornography. And that's what I'm here to, raise on appeal.
And wasn't the objection that it just went to show propensity without more, whereas now on appeal the argument is that there wasn't sufficient evidence to link him to the Williams Rule evidence?
He objected, saying it didn't satisfy the Williams Rule. He said, sorry, Your Honor. He said it goes to propensity without showing a whole lot more. And our argument here is that a whole lot more did need to be shown. They didn't prove by clear and convincing evidence that this was even child pornography. They don't even have the images. All they have are titles. They don't even know, they're just alleged images. We don't even know if those images ever, existed. There's no proof. They didn't even tell the jury what the titles were.
He's not charged with possession of pornography on those images. The relevancy of it was as to whether he knowingly possessed the other items, correct?
Yes.
So it went to his state of mind, correct?
Yes, and that was his whole defense. His whole defense was that he accidentally viewed.
Right.
And then the state had no other evidence that he possessed any child pornography for any length of time. So this was a critical, and that gets me back to, even if you don't find that it was preserved, this was fundamental error. If ever there was a case that was fundamental error, this was fundamental error, because it goes to the core disputed issue, his whole defense, which was that he accidentally viewed it and then he immediately deleted it. And the state presented evidence that this Lolita 238 folder, which we don't even really know what it is, but they said the title Lolita might indicate child pornography.
Was this the only evidence, though, that the jury could have concluded that he was intentionally downloading this sort of images? I mean, he talked about the Sandra Teen model. He talked about, where images would be on his computer if they were going to be there. He said it wasn't a fluke that the officers were here and that sort of thing. So how's it fundamental error when there's, whether or not you disagree or, we agree with it, there was other evidence that the jury could have based the same conclusion on?
I think that if you go back and you listen to those two interviews and you put everything in context, this is a man who, yes, they asked him where child pornography was on his computer after discussing adult pornography. I don't want to forget this. In the course of discussing his adult pornography, he said, yeah, I'm interested in teens. I go to this site for teens that are actually partially clothed 18 to 20. That's the teens he was talking about, and he explained it, and even gave him the name of it. And then when they asked him later about, if there was where would child pornography be? They didn't say, is child pornography there? They said, where would it be? Because he repeatedly told them, you're not going to find child pornography there. All you're going to find are deleted torrents that I immediately deleted. So he said, and I quote, if anything was going to be there, it would be on my external hard drive. And that's because, in this certain file, and that's because that's where he stored all the adult porno and all the movies and everything that he downloaded from this sharing program called BitComet. So that to me does not mean that he confessed in any way whatsoever. He testified that he felt very guilty because he was married, his wife was ultra-religious, and I think that explains a lot of his statements about him being a scumbag, him feeling like he was a terrible person. And I think that he repeatedly said, I'm repulsed by child pornography. After saying, this cryptic statement, if anything was going to be there, he repeatedly says, I'm repulsed by it. When I see it, I delete it. I think of my 2 kids. I don't call that a confession. I just don't.
You don't even think there's an inference there?
Not if you take all of it in context, because he never said that he knowingly downloaded child pornography.
Well, I don't know that he needed to say that for there to be an inference. That wouldn't be an inference.
I don't even think there's an inference because of the way he was explaining things. He said, in fact,
Could the jury reject his testimony?
Yeah, well, the jury, of course, is free to reject his testimony, but that still leaves the 2 pretrial interviews. And I would submit that those pretrial interviews are cryptic at best.
I'd like you to address the double jeopardy issue.
Yes. Thank you, Your Honor. So this is, I submit, an issue of first impression. And I'm not, as the court knows, there's these 2 statutes. There's the simple possession statute, and then there's the one that I'm going to call possession plus, which was the count 1 statute for the 10 or more images. And our position is that the possession plus merely aggravates the possession statute. And so under Florida law, he can't be convicted of both possession and possession plus arising out of the same conduct. And for that, we're relying on the double jeopardy statute. It's actually codified statute 775.021(4)B that prohibits a defendant from being convicted and punished for the same same conduct multiple times if the conduct arose from the same episode or transaction and the offenses are merely degrees of the same offense.
Counsel, what's the conduct here? Is your definition of conduct one image, which was charged in count one? Or is your definition of conduct all of the images?
My definition of conduct is each image is conduct, and the conduct arose from the same episode or transaction. Because, for example, if you have the individual possession of 10 photos, A through J, and then you get charged with possession plus, based on your possession of the same photos, A through J, you have been convicted of possession of the same photo twice, and that's the
The
same.
photo in count one, as best I could tell, was only charged once. I didn't see it charged anywhere else.
I'm sorry,
Can you,
misunderstood.
the image that was charged in count one,
Yes?
which is the count we're talking about,
Yes.
I looked through the record, I scoured the record, I couldn't find anywhere where that image was charged in any other count.
think
Can you
that's-
point me to what I'm missing?
I think that's true, Your Honor, but.
Okay, well then how is he being convicted for the same conduct twice?
Because he's being convicted actually of that photo, plus 10 other photos that he's also being convicted of. So, he's being.
Well, no,
convicted-
he's being convicted of that photo, and then it's a second-degree felony because he had 10 or more.
Yes, it's a different degree, I agree. And that actually, in my opinion.
But he's only being convicted of the one image in count one.
No, he's being convicted of possession of 10 or more images, and that particular image is the image that they selected, that they said contained the other criteria. So that's why that was in there. But he still is being convicted at the same time for the possession count images and the other images I would submit.
And isn't that exactly what the legislature intended, according to the plain language of the statute, which contemplates that the possession of each image will be a separate offense?
Well, the possession of each image should be, yes, I agree, should be a separate count. But we have to look back to the Valdez case, the Florida Supreme Court case, that says when a crime may have aggravated forms of the basic offense, this can evidence a relationship of degree. And if the offenses of conviction are merely one degree of another, then that violates double jeopardy. That's an exception to the double jeopardy clause. And that's what exactly is the case here, because when a crime has aggravated forms of the basic offense, this can evidence a relationship of degree. That's what the Florida Supreme Court said. So here what you have is a crime that's an aggravated form of the basic offense, and it's really a different degree of the child pornography offense.
So essentially, what your argument, I think I understand it. You're saying that what the state should have done is in count one, charge 10 of the images as one second-degree felony, and then charge the remaining 47 as third degrees. They could have done that.
No, because.
Why not?
I don't agree.
Well, then there'd be 10 images supporting count one. I mean, I'm just sort of.
You mean 10 different ones?
Yes, I'm following I'm not saying I agree with the argument, I'm just following your argument. I'm making sure I'm following it.
Yes.
Your 10 different images in count one
Yeah.
would have been a second-degree felony. And then the remaining 47 images could have been charged as individual third-degree felonies, according to your argument.
Yes, that's true.
Or they could have lumped 10 together and done multiple second-degree felonies under your argument.
Yes, just like they did in Walsh. And actually, Your Honor, there is no other instance that I could find where they did this type of charging. And I submit that's because it's wrong, but it is an issue of first impression.
Why don't you save the remaining time for some rebuttal? I'll give you a little extra time.
Thank you, Your Honor.
May it please the court, counsel, good morning. Kelly Nealon on behalf of the state of Florida. It appears to me the court's fully grasped the state position in this.
All right, let's start with the double jeopardy.
Okay,
Walk through that analysis.
I'm sorry?
Walk through that analysis.
Well, the Walsh case, I mean, it's legislative intent. You don't even get to the legislature's Blockberger statute. The legislature enacted a reclassification statute which said a picture which you possess along with 10 other images containing a certain type of child pornography is a second-degree felony. And that's the end of the analysis.
And can you charge then those 10 images individually?
In other words, could the state have charged 58 second-degree felonies here?
No. So you've got the one count, you've got one photo that meets the statutory criteria, and there's an allegation that there are 9 other images.
Okay.
Can you charge, for instance, those 9 other images individually?
Yes.
Okay. And that's what they did here.
Yes. Yes, and as the Walsh court pointed out, I mean, there they broke it down into groups of 10, like you were asking, Judge Eisnagel. But in this case, they only did it for the one count.
So the one count, they use 9 of those images once for that purpose, to aggravate the count up to a second-degree felony. And then they charge again the same 9 images and charge that conduct as well.
Correct. Each is a third-degree felony.
And it's your position that they could have charged 58, it was 57 or 58 files here?
58 counts altogether.
It's your position they could have filed 58 second-degree felonies, right?
Correct.
And that's just based on the language of the statute and sort of the plain meaning of what the statute says?
Yes. Yes, which is the first thing you look to is
Well, but you still have to go through double jeopardy analysis. The fact that the statute says something doesn't mean that the statute doesn't violate double jeopardy principles.
Well, yes, it does. It's legislative intent. I mean, the legislature can name whatever crime they want. The legislature could say, I mean, I know there's a lot of case law out there about you can't charge more than one murder, the one body rule. But if the legislature came out with a statute that said you can do that, then yes, you can do that. That's the first question in a double jeopardy analysis. I mean, you might be able to charge down the road, cruel and unusual, some other constitutional violation, but it is not a double jeopardy violation.
Is my reading of the record correct that the file in count 1 was not charged again in any other count, correct?
Correct. And you can look at the judge went through each image on the JOA argument, and there clearly were 58 different images. The judge described what was in each of them. So none of these images were used as duplicates in the separate counts. If there's no other questions, then I'll rely on my brief for the remaining issues.
Okay?
Thank you.
Your Honor, I think...
Since she left 16 minutes, if you need some extra time on rebuttal,
Thank you, Your Honor.
Don't worry when it turns to red.
Okay, thank you, Your Honor. So with respect to the double jeopardy issue, which is the only issue that was discussed by the state, I think we've made it clear in our briefs that the Walsh case is merely dicta, and it does not involve, as the court is aware, the same facts as us, and it never even, in fact, went into the Valdez Florida Supreme Court case analysis of what makes something constitute double jeopardy under the Florida double jeopardy statute.
Isn't that because there wasn't multiple convictions for one act? Because each possession of each image is a separate act. Here, there was only one conviction for a possession of an image. So the double jeopardy analysis, the court didn't need to get there because there wasn't multiple convictions.
I'm not sure if I understand the court's question. I'm sorry.
Well, it's similar to the state's argument that because there was only one charge for the conduct, which is possession of a photograph, that the court did not need to reach the double jeopardy analysis because there wasn't multiple convictions for a single act.
Well, I'm not sure I understand the question, but I definitely think that the facts show that there were multiple convictions for one act here.
I think that it seems that the point that you're trying to make, and correct me if I'm misunderstanding it, is because these 9 other images were used to bump up the crime from an F3 to an F2, so they're used effectively to aggravate the possession of the one image, that you can't then take those 9 images and charge them separately. That's the argument you're making, correct?
Yes, and it's similar to the Gill case, because we don't have any on-point cases, but the Gill case, which I cited in my brief, which is a Florida Supreme Court case, is analogous, I feel, because, and it's persuasive, because there, like the state was just saying, just because the legislature passed it this way, passed 2 different statutes, that's enough. Well, that exact thing occurred in Gill, and that wasn't enough. They had a person who was charged with driving with a suspended license, and then they were also charged with being a habitual traffic offender. There were 2 different statutes, but the court held that it violated double jeopardy, even though there was, different elements to the crime, and that they found that the habitual trafficking offense was merely an aggravated form of the driving with a suspended license
But it
offense.
still comes down to whether the use as an enhancement constitutes a conviction for double jeopardy purposes.
That's correct.
Right.
Yes. And the rationale of that court, I would submit, is directly applicable to our case, because possession is clearly a predicate offense to the possession plus offense, and the offenses are merely degrees of each other, because this first count just really aggravated, is an aggravated form of the mere possession counts. So that's all I have, unless the court has any other questions.
All right, thank you very much for your presentation.